Good evening, ladies and gentlemen. My name is Attorney Edward Berkman, and this is the Common Law. Welcome back to the program. We took some time off for the summer, and we're getting going for the fall. The leaves are falling, and it is, becoming spooky season. So don't let the law scare you. It's nothing to be that afraid about. Tonight's a special episode. We're going to do a bit of a two-parter. The first half is going to be me going over some components of the deed to your house. If you're recently purchased a house or thinking about purchasing a house, this will be some good information for you. And then there will be a second part, which will be about homesteads, which is also relating to home ownership and home purchasing. And we'll go over all the ins and outs on what a homestead is, how you can check to see if you have one, and whether or not you need one or not. Spoiler alert, you're going to need one, or you should definitely file one. And you probably already have one. So tonight, we're going to get right into it. The topic we're going to start off with this evening is sort of understanding your deed. Now, the deed is the instrument that just proves that you own the property in question. So if it's your home, the deed says that you own your home. In Massachusetts, a deed needs to be signed in front of a notary, and that needs to be signed by the person who is deeding the property. So if you're buying or selling a property, it's going to be the seller who is signing the deed. So you don't actually sign your deed, it's the previous owners who sign it. And then you should be recording your document, which is the deed, with the Registry of Deeds. Now, in Massachusetts, the cost to record a deed is currently $155. Please keep in mind if you record online, or if it's a sale, there may be other charges that are associated with that recording. So make sure, don't hold me to the $155, but that's typically what the base recording charge is. Now, the piece of the deed that grants you the ownership is what we typically call the vesting. Now, the vesting is the area of deed with your name on it. It's printed out, showing that you're the owner of the property. This will also give you the amount of money that you paid for the property. Now, if you received it as a gift, or if you're deeding away property into like a trust or something like that, it might say consideration nominal or for $1. That's what we call the consideration for the deed. Even if it's no real actual money, we still should have something there. So it should say, nominal. I always put $1. And the vesting will always show the tenancy, which if you buy a property with somebody else, that's known as joint ownership, and you would have a form of tenancy associated with that ownership, and we'll go into that a little bit further. So there are three types of joint ownership when you purchase a piece of property. The first one, and this is the default version, is tenants in common, followed by joint tenants, which could or could not have rights of survivorship, and that's followed by tenants by the entirety. So let's break these all down one by one. Tenants in common is the default. So if there's no tenancy defined, so it needs to say the words tenants in common or joint tenants with rights of survivorship or tenants by the entirety. If it doesn't explicitly say that in the vesting, then the tenancy is going to revert to tenants in common, which means the person that you own the property with, you both own, basically, if it's two people, an undivided half interest in the property. We're not drawing a line through the property. This is my half, that's your half. It's basically, we both own half, if it's two people. We both own half the property, but we own half of it undivided. We own a half of the entire property. Now, tenants in common does not carry with it what's known as a right of survivorship, which means if you were to pass away, your estate still owns that portion of that property. So if it's in tenants in common and you pass away, and you want to sell the property, say you buy a house as a married couple, and there's no tenancy listed, so it just defaults to tenants in common. And your husband dies. Well, if you want to sell the house, now you need to open up your husband's probate the estate, because his estate still owns an interest in that property. Now, you might be asking, well, of course you would. Why wouldn't, like, if I buy a house, I want to make sure that I own it and I can pass it down to my kids and probate and things like that. So typically, if you wanted to maintain that ownership status after you die, you definitely need to have the vesting say tenants in common or not have anything listed at all. The next form of tenancy for joint ownership here in Massachusetts is joint tenants. So joint tenants means, again, you own the property jointly with at least one other person, and it's an undivided interest. And joint tenancy can have with rights of survivorship or without rights of survivorship. Without rights of survivorship, it's very similar to tenants in common. Once you pass away, your estate continues to own that portion of that property, that sort of undivided interest. If joint tenancy says joint tenants with rights of survivorship, well, now you co-own the property with the other parties, but it's the last surviving person ends up owning that property. So if we go back to our example of a married couple buying a house, if the husband dies and it's joint tenancy with rights of survivorship, which it wouldn't be, that would actually be tenants in common. So let's adjust our hypothetical for brother and sister buying a property. The brother passes away, it's joint tenancy with rights of survivorship, and that means when the brother dies, the sister now owns 100% of the property. The surviving owner continues to own the property in full. So in this instance, the brother wouldn't be able to file, someone wouldn't be able to file an estate claim or a probate for his interest in that property. He would cease to own it at his death. And the third we have here in Massachusetts is tenants by the entirety, which is similar to joint tenants with rights of survivorship. It does carry with it that right of survivorship, but in order to have tenants by the entirety, the people need to be married. So you can only have two people with tenants by the entirety. So you have to be married. You have to, and there's a couple other things you need to have in order to qualify for joint for tenants by the entirety. You need to come into the property at the same time. That's the same thing with joint tenants. So you couldn't say buy the property and then, say your brother or something wants to buy it into the property as well. You couldn't do that with tenants by the entirety. One, you're not married to two people, and with joint tenancy with rights of survivorship, you're not coming into the property at the same time, which is important. There's other interests in property you may have. Those go into like fee simple absolute. We'll go over those again another time. But one is sometimes people will say, well, how do I own a property to avoid probate? And so that is, you want that right of survivorship in your vesting. So you want either tenants by the entirety or you want joint tenants with rights of survivorship. That way, if one party dies, you don't have to open up a probate to sell the house. The other person, the surviving owner owns it indefinitely till they pass. Another way you could avoid, probate with home ownership is putting the house into a trust. You could have a living trust, an irrevocable trust, or a realty trust. You can put the property in any of these trusts. I think that's the best way of doing it, actually. It's 100% safe from probate. You don't have to worry about it all that much. We oftentimes, as a real estate attorney, I oftentimes see deeds with incorrect vestings. So it's just not done properly. But if it's in trust, you don't have to worry about tenancy because the trust just owns it. You don't have to worry about joint ownership in Massachusetts. The things with tenants by the entirety on a deed, though, it needs to say tenants by the entirety. It needs to have that written on the deed. Sometimes you'll see a deed where it just says husband and wife. So it's John Smith and Jane Smith own the property as husband and wife. Well, that doesn't create tenants by the entirety, even though you're stating that they're buying it at the same time and they're a married couple, husband and wife. That's not going to meet the requirements for tenants by the entirety, because the words tenants by the entirety aren't listed on that vesting. So what happens in that case, it drops down all the way down to tenants in common, which means if one of those spouses passes away, you have to open a probate for that. So that's one way of, avoiding probate. Like I say, the best way of doing it is just putting the house into a trust. There's also what's known as a life estate deed. And this is where you own the property, but only for the rest of your lifetime. Once you pass away, so does your interest, and then a defined remainderman would take over the ownership. So a lot of this happens when, people get older and they want to leave their house to their kids and they don't want it to go through probate. So what they do is they will create a new deed where they deed it to themselves. They deed it to themselves with an interest of a life estate in the deed. And then the remainder, so the interest that relies after they pass away, that goes to their children or to somebody else. Property won't have to go through probate for that. You will need to record a death certificate after that person has died, though, so you can prove, in fact, that you do, own that interest. The tricky thing with life estate deeds, though, sometimes is if you were ever to refinance the house, you're going to need both the person who owns the life estate and the person who owns the remainderman, or the remaining interest. They're going to have to sign that, sign off on that refinance as well. So even though their interest doesn't take place yet, they still have an interest in the property, and they're still going to need to go off and actually sign that. So that's going to about wrap things up for part one of our episode this evening. I'd like to just remind everybody, although I am an attorney, I am not your attorney. So if you ever have an interest or a question, please reach out to me or another attorney. Don't take anything that we say here as true legal advice. Even if there is an instance where you feel like the fact patterns or the examples that I'm providing meet your issue or your dilemma that you're dealing with, please trust me in saying that the devil is in the details when it comes to this stuff, and you really should contact an attorney and go through it step by step, piece by piece. So please do not consider this legal advice. But if you do have a question, my email is right here. Please write me an email, give me a phone call, and I'd be more than happy to help you. So I'm going to kick this over to myself, and we are going to start going over things also dealing with real estate law, and that is a homestead. And so we'll move on to the next segment of the show. Hello, everybody, and welcome back to the Common Law. I'm your host, Attorney Edward Berkman. We don't have a guest this evening, so it is just me. So I want to take the time to break down a very common, very useful area of real estate law that everybody who owns a house or even a manufactured home, mobile home, should consider looking into. I want to preface this like I preface every episode. Although I am an attorney, I am not your attorney. If anything we talk about sounds related to your legal issue, please know that it is not. Legal issues are heavily detail-oriented, so one small detail could throw the whole case off. So if you do have a legal question, please feel free to call me, email me. That information is at the bottom of the screen right here. Feel free to call, text, email, whatever you need. Don't worry about if it's a night or a weekend. Reach out to me. I'd be more than happy to help you. Even if I can't help you, I will get you in touch with an attorney who can. Now, without further ado, the topic for tonight's episode is dealing with homesteads. Now, homesteads apply to home ownership. If you've purchased a house, you've probably have a homestead. Most real estate attorneys prepare these for you at the closing. But what a homestead is it is a document that you may or may not file with the Registry of Deeds, that basically telling the world that you own this house, this is your primary residence, this is your home. And what this does is it protects any equity that you have up into the house, up to certain limits, and we'll get into that in a little bit. So it's just protecting equity that you own in the house. Basically, if you were to get into a situation where someone was trying to force the sale of your house to settle some debts, a homestead would prevent that from happening. That doesn't necessarily absolve you of those debts. Like we said, it just protects the equity, keeps you in your house, and you can settle your debts, and through other means, basically. Now, the reason why I said it is certain debts, a lot of people think of, oh, great, I have a homestead, I don't have to pay my mortgage. Well, it's really only unsecured debts. Your mortgage is basically a loan that's secured by a mortgage interest in the property. The bank owns that mortgage interest, and that's recorded with the Registry of Deeds. Anything that you would have to sign off your, house, are you putting up something for collateral? Well, what you're doing is that collateral is securing that debt. So a homestead wouldn't protect anything that's secured through a mortgage or another sort of promissory note or a document like that. Moving on, there are 3 types of homesteads. These all are going to relate to the amount of money of equity, or the amount of equity you own in your house, how much can be protected for certain things here. The first type of homestead is the automatic homestead. This happens automatically. It's by law. And this homestead basically protects the first $125,000 of equity you have in your house. Like we said, it does not need to be filed with the Registry of Deeds. It happens automatically. Every owner on record is entitled to that homestead. Not only every owner on record, which would be the names on the deed, also family members who live there and call that property their primary residence also would have that automatic homestead protection. Again, that maxes out at $125,000. So if you had some credit card debt, maybe your identity was stolen, maybe you got into a car accident and you didn't have insurance that would cover the full cost of the accident. Well, someone might sue you, and your greatest asset is oftentimes your house. And so this protects that initial equity investment. So long as you don't own more than that $125,000 in equity, they're not going to be able to force the sale of the house, and you'll be able to continue living there. Now, the total amount protection on automatic homestead is $125,000. That doesn't matter if there's one person or if you have a large family, like 8 or 9 people living there, that calling that place home. That's $125,000 no matter what. Everyone doesn't get their own $125,000. The next homestead, and this is the most commonly used homestead, and that's what we call a declared homestead. And this is the document that you would file with the Registry of Deeds. It doesn't happen automatically. You have to actually file a document that you're declaring a homestead. And what does that give you? That bumps up that equity protection similar to the automatic homestead, but this is bumping up that equity protection up to $500,000. So if you own $1 million house and you have a mortgage for $500,000, you have an equity stake of $500,000 in that house as well. And if you had declared a homestead on that property, well, that equity that you own, that investment that you've made, that $500,000, that is protected. Now, a person can only have one primary residence. So you couldn't, if you owned multiple properties, you couldn't file a homestead on each property. You only can do this once. And it also protects, family members that live in the home, at the property, to declare that their primary residence. It protects everybody who lives there. Again, that equity stake is going to be capped out at $100,000. And that's, again, the total protection for the people at that property. Total protection is going to be that $500,000. Now, because this has to be recorded, you are going to have to pay a recording fee to record such a document. The registries charge typically $35 to record such a document. If you do it online, and every registry is different, there may be some additional fees that are associated with that transaction. So please don't hold me to the $35. It may be $5 or $6, $7 more, depending where you file, where your property is located. The last type of homestead is what we would call an elderly or disabled person's homestead. Basically, this is the same as a declared homestead, where you would need to go to the registry and file a document, file a homestead document that says, basically, I live here, this is my home, please don't make me homeless if something were to happen. The big difference with this homestead is multiple people can file their own homestead on the property. And those homesteads can be tacked onto each other, which can protect the equity owned in the house up to $1 million. So basically, what does this mean? That means if you qualify for an elderly homestead or disabled homestead and you have a spouse, you both could file your own homestead, and that would protect the equity you own in the house up to $1 million. In order to qualify for this type of homestead, you either need to be 62 years of age or have a legally defined diagnosed disability. And that's something that, if you think you may qualify for either one and you have a question on it, please feel free to reach out to me. We can certainly check to make sure everything is smooth and everything is how it's supposed to be. Now, moving on, there are some limitations to a homestead, and I don't want anybody to be confused here. So the biggest comparison homesteads get is, it's insurance. I don't have to get insurance anymore. That's not true. You still need a homeowner's policy. If you have a mortgage, you're going to be required to have homeowner's insurance. Some people think it also qualifies as this would fall under some sort of liability insurance. Although it does help with liability, it is not liability insurance. The big takeaway here is that it doesn't absolve you of any of these debts. If you're held liable for something and you owe a sum of money, a homestead is not going to absolve you from paying it. That needs to be worked out. What it does is it stops them from forcing the sale of your house. Again, if you owned more than if you had a automatic homestead and you owned more equity than $125,000, well then yes, you may have to be forced into selling your house to settle those debts because that initial 125 has been reached. Now, if you sell the house, that does mean you get to hold on to that 125,000, so long as there's other things going on. Again, the devil's in the details here, folks. So if you do have a question on this, please reach out to me. Let me know. We don't really have the time to break down every single scenario here, but it's a good idea to have a homestead, and that's really what the main purpose of this episode is tonight. Again, we've already talked about this, but it's only unsecured debts. So things that you didn't have to put up any collateral for, that would be used here. Now, some people question, well, what happens if I declare bankruptcy? And that kind of opens up its own box of problems and issues there. So the basic answer to, does a homestead protect my property through a bankruptcy? The answer to that is it's going to depend. It's going to depend on a lot of different factors. There's two different chapters of bankruptcy you can file under in Massachusetts, Chapter 7 and Chapter 13. And we're not going to get into the details on that this evening, but basically it can go one of two ways. And it really all depends on what your debts are, how much you owe, how much equity the house is worth. A lot of things come into play there. Now, how do you know if you have a homestead? Now, you could go to the Registry of Deeds and you could look it up. If you go there in person and you just ask for help, chances are, they might be able to help you. It again depends on which registry you're going to. You might have more luck some places than others. Here in Newburyport, we fall under Essex County South, which is located in Salem, Massachusetts. And I can contest, I've worked there, many times. I've done numerous amount of closings at that registry deeds, and everybody there is fantastic. So you shouldn't have too much trouble there. But they are extremely busy, and you shouldn't be going there to ask for help with a homestead. So I'm going to offer all of my viewers and listeners out here today, if you have a question, whether or not you want someone to check to see if you have a homestead or what kind of homestead that you have. Again, my information is down at the bottom of the screen here, folks. Reach out and I will check that for you for free. So reach out to me, just tell me you saw the show, tell me how I'm doing. And if you'd like, I can look up to see if your homestead status is. If you have one, I'll let you know. If you don't have one, I'll let you know. And if you want to use me or another attorney to prepare one for you, we could do that as well. So don't stress. Everybody should have a homestead. It's not required. You do have that automatic homestead protection, so you're not forced into needing to file something, especially if you don't have a lot of equity in your house. This does cover mobile homes and manufactured homes. Only caveat being is it has to be your primary residence. If you have a camper sitting in the driveway that you take up to New Hampshire for vacations, you really couldn't apply a homestead on that. And everything else would just be a typical real property situation, so an actual deeded properties. That's this evening. I know this was a quick episode. I'd like to thank everybody for tuning in, and I will catch you next time at Common